Good afternoon, everyone. Thank you so much for attending today's event. My name is Ashley Cummins. I am a staff attorney at Eastside Legal Assistance Program. Today's presentation is going to be focusing on what to do if you get an eviction notice. And so we'll go over the kind of like agenda here in the next couple slides, but that's basically the general presentation. A little bit about me. I previously worked as an attorney in Nevada Legal Services in Reno. Down there I also did housing stability work, as well as additional legal aid issues like Social Security, Medicaid, Medicare, unemployment, kind of whatever came in through the door I tried to help out with. Previously, I interned at McNeese Wheeler in Spokane, as well as the Center for Justice and Unemployment Law Project. I went to Gonzaga for law school. I went to WSU for undergrad. So come December with the Apple Cup, it's gonna get pretty heated in my family. But that's a little bit about me. Next slide. All right, so the outline of what we're gonna talk about today. So again, the first thing we're gonna unpack are evictions for non-payment of rent, simply because this section of the law changed significantly as a result of the pandemic. Landlords have a lot more requirements that they have to go through, and tenants have additional rights that oftentimes they don't know about. So we're going to talk about the repayment plan that your landlord is required to offer you. We're going to talk about the eviction resolution pilot program and mediation and what that means. We're going to talk about the 14-day notice that you should receive, a summons and complaint, and post-moratorium late fees. Then we're going to switch into just cause evictions, because that also changed in the last couple years. Now, in most cases, landlords have to have a reason to evict you. So we're going to go over some of the most common notices that I see, as well as a few examples of others. And then we're going to talk about unlawful evictions, so what that means, what your landlord cannot do. Then kind of like a quick, okay, so you got a notice, now what? And then open it up for more questions. But again, if you have a question during it, please just feel free to raise your hand. Okay, so evictions for non-payment of rent. So just to give you a kind of overview, because we're going to unpack these three things in the next few slides. To start an eviction for non-payment of rent, your landlord has to do three things now. They have to give you a reasonable repayment plan, which we're going to talk about. They have to give you a 14-day notice to pay rent or quit. They're going to have to give you an ERPP notice, which is a 2-page document that talks about the eviction resolution pilot program that requires landlords to go through mediation if a tenant requests it. King County Dispute Resolution Center is in this room earlier, so you might have heard them talk about this as well. So for the payment plan has to be reasonable. Now, did the lawmakers make my job easy and define what reasonable is? Of course not. That'd be too easy and make things too nice, right? So it does have to be reasonable based on your circumstances. It also has to allow payment from other sources of income. So it can't say, hey, if this payment plan, if you make a payment on it, it has to come from a personal check, or it has to come from, a cashier's check with your name on it. You can use outside resources and agencies to pay the payments under the payment plan. What it cannot do is it cannot be more than 1/3 of your monthly rent. So for example, I know rents are not this low, but I am not good at math, so it's easy for me to say, let's say your rent is $300. If you're behind on rent and your landlord offers you a payment plan for that back rent owed, it cannot be more than $100 a month. It's important to remember this payment plan is separate from your lease agreement. They oftentimes run together, but they are separate agreements, meaning if you're renting under your lease agreement, the lease is up and you decide to move out, but you signed a payment plan and you're still making payments on it, that payment plan will continue to run. So this $100 that we just talked about as an example is in addition to your monthly rent. So the offer by the landlord, it cannot be more than 1/3 of your monthly rent. It cannot require the first payment to be within 30 days from the date the payment plan was offered by the landlord. Not the date that you signed it, but the date it was offered. It cannot include late fees. It cannot include attorney's fees. It has to be only for rent. And rent is defined as a monthly reoccurring charge that's identified in your lease agreement and connected to your ability to remain in that unit. We usually look at like what you'd call like base rent, right? Like your normal rent. But some other examples might be a parking space charge, a monthly parking space fee. Another example might be utilities. If you pay your landlord for the utilities directly, that oftentimes is identified as rent. It's important to read your lease agreement. If you're paying the utility company directly and not landlord, that's between you and the utility company, right? So that's not going to be rent. But more often what I see is the base rent, I see utilities, and then I see like parking space fees. I've seen like a laundry facility rental fee. It was like to get access to the community laundry facility. But those kinds of things, those monthly charges are considered rent. Late payment or late fees, not rent. Attorney's fees, not rent. And it cannot be conditional on you following your lease agreement. They are two separate agreements. The landlord can't say, okay, tenant, sign this payment plan that I'm offering to you, but if you don't pay your monthly rent under your lease agreement, I'm going to count that as you also violating this payment plan agreement, and now both are off the table. They are separate agreements. They're not dependent on each other. Next slide. Okay, so here's kind of like an easy flow chart of what happens when you get the payment plan. I will make a note, oftentimes tenants are receiving all three notices at the same time. That payment plan, the 14-day, and the ERPP notice. Landlords are not required to give it to you all at the same time, but that seems to be the trend, which of course makes it that much more stressful for a tenant to be on the receiving end of multiple notices and being like, which one do I follow? What's going on? But for the payment plan offer, landlord offers you a reasonable repayment plan, and then they have to wait 14 days, which is why we usually see it be served with the 14-day notice, so that those 14 days kind of run at the same time. But they have to wait for 14 days. And during those 14 days, tenants have three general options. First, you should review the amount that your landlord is saying you owe, right? And make sure that that amount is correct. Make sure it doesn't include anything outside of your monthly rent. Ask for a copy of your ledger. Do the math on your end. You know how much your monthly rent is. You know what you've paid. If something is wrong or you disagree with the amount owed that's on the payment plan, don't sign it. Say, hey, I want to enter into a payment plan with you, but the amount you're saying I owe is incorrect, and here's why. But let's say landlord does everything right. You double check the math, it looks good. You've confirmed with your budget that this amount, the 1/3, is something that you could pay, right? You can make those payments. You're secure in your knowledge that you'll be able to pay the payment plan and your monthly rent on time. And you've double checked everything and all looks good, so you could sign it. Okay, great. Sign it. 30 days from the date that it was offered, that should be when your first payment is due on the payment plan. Mark it on your calendar so you have technically two due dates now, one for rent, one for payment plan, and the end. As long as you make those payments, you should be good. Let's say you look at it and you're like, oh my gosh, that's too much. You can make a counter offer. You could say, I can't pay the $100 a month, but I could pay $50. Or let's say that the way the payment plan was offered to you, the first due date is going to be the 1st of next month. And you're like, my paychecks, I get paid twice a month. My first paycheck goes to pay my rent. It's going to be hard for me to pay both my rent and the payment plan on that same paycheck. So you could counter offer by saying, hey, landlord, could we have the payment plan be due the 16th of every month so I can use my second paycheck to pay it off? A counter offer is different than disputing it, right? So when I said make sure the amount you owe is correct, at that point, you're disputing this payment plan. Hey, I disagree with it. You can still, though, counteroffer. I disagree that that's the amount I owe. Here's how much I owe. I could enter into a payment plan for that with terms that look like X, Y, and Z. Or you could reject it, just flat out, like, nope, this does not work for me. I cannot sign it, or not respond. If you counter it, you might be opening up a dialogue with your landlord to come up with an agreement, right? And if you do end up coming up with an agreement that works for everybody and you sign that payment plan, the eviction process should stop. There's no reason landlord would move forward with that. If they do, contact a legal aid organization because something's fishy. But if you reject it, or you and your landlord cannot come to an agreement after the counteroffer, or you simply do not respond, landlord can move forward with the next step. It is really important to make sure, even if you get this payment plan and you're like, no, there's no way I could keep up with that, save these notices, because here's the thing, the statute says if the landlord does not offer you a payment plan that complies with these rules, that is a defense to the eviction. You can't cure or fix landlord's inaction, right? So if landlord never offers you a payment plan, but you owe rent and you want to get ahead of it, you can, right? I wouldn't recommend waiting and having that balance accrue. You can certainly start that conversation with your landlord and try to come up with an agreement about a payment plan. But remember that the law says landlord is the one who has the duty to make this offer to you. And you having a conversation with landlord about what you owe or what you could pay does not waive landlord's duty and requirement to make an offer to you. Okay, next slide. All right. So then now let's say, unfortunately, the payment plan that was offered by landlord didn't work for you, or you guys weren't able to come to an agreement. It's now going to go through the King County Dispute Resolution Center or Bellevue Resolution Center if you're in Kirkland or Bellevue. Since we're here, I'm not going to talk about them. We'd be looking at KCDRC is the acronym we use for the Dispute Resolution Center in King County. What they do is provide mediation, conflict coaching, individual consultation, group mediation, facilitation, training. They do a wide variety of things, okay? They're not just there to help with 14-day notices and the ERPP process, but that's what we're gonna talk about today, is that one section of what they do help with. And then we do have information for their contact info. So, like I said, you're gonna probably get all 3 notices at once. The 14-day, the payment plan, and the ERPP notice. What landlord has to do to start the process with mediation is they have to give those notices to the Dispute Resolution Center and say, hey, KCDRC, I'm a landlord, I gave these notices to my tenant, I want to start, this process. And then what the Dispute Resolution Center will do is reach out to the tenant and say, hey, your landlord has enrolled you in this program, please, fill out a self-assessment, work with us so that we can look at scheduling this mediation if that's something that you want. If you don't know where you stand, right? If you've gotten these notices but you haven't heard anything from the Dispute Resolution Center, it might be because your landlord hasn't actually started the process. It happens more than you would think. But don't fear, there are ways you can figure out where you are. ELAP and Tenant Law Center and Northwest Justice Project partners with KCDRC every Thursday, and we do a housing clinic where you have an opportunity to talk to DRC staff, get an update on where you're at. There's also a presentation done by Solid Ground, and I'm usually there as well, that goes more in depth about what to expect at a mediation, what kind of offers and counter offers you might make. And then you have opportunity to talk one-on-one with an attorney. It might not happen in the clinic because of a time crunch, but we do have overflow spots available, and we try to speak with tenants. There's also a tenant inquiry form that KCDRC has online. So if you get these notices, I highly recommend you fill out an inquiry form and or register for their weekly clinic, because then you'll be able to determine, do I fall into the category where I've gotten these notices, but my landlord hasn't actually started the process because they haven't notified the DRC, so no case is really open. Have I gotten these notices? My landlord has provided the copies of the information to KCDRC, and they actually tried to reach out to me to fill out a self-assessment form, but I didn't get the form for some reason, or sometimes people get confused because you might get a text message and you're like, who's this? What's going on? Do I need to talk to DRC staff to fill out that form and make sure I request a mediation? Or am I all the way on the other end where I've gotten the notices, landlord has done what they're supposed to do by giving it to KCDRC, I have done what I'm supposed to do by filling out that self-assessment form and requesting a mediation, and now I'm just in line to get the mediation scheduled. So if you have a question about what kind of lane you're in, go to this weekly clinic. There's people there who are willing to help you, attorneys who can give you advice, and wonderful KCDRC staff who can inform you what steps you need to take to request that mediation and confirm if you've taken those steps. Okay, next slide. Okay, so we've already kind of talked about this, but I like to repeat myself because I know that it's a complicated process, and we are using a lot of acronyms and a lot of notices. But again, a flow chart for us visual learners. Okay, now we have the ERPP notice. That's that 2-page document that talks about your right to have a mediation if you request it. Usually comes with the 14-day, usually comes with the payment plan. Again, you have 14 days to respond. In this situation, 14 days to respond would mean if landlord provided a copy of this to the Dispute Resolution Center, that starts the 14-day clock. Because the DRC is not going to just magically know, right, all of the tenants who've received the notices unless landlord clues them in. And so I would recommend you act as though that 14-day deadline has started the same day landlord gave you those notices. I recommend you think, okay, pretend like you know your landlord gave those copies to the DRC, because then you're going to be on the safe side. So that means in those 14-day notices is I'd recommend attending one of the weekly clinics, right? Confirming where you're at. You might know where you're at because you might hear from the DRC and they might say, hey, here's the self-assessment you need to fill out. You know that once you fill that out, you're just in the line, waiting line to get scheduled for mediation. But they do have to wait 14 days, they being landlord. Let's say tenant fails to respond. In this case, fails to respond would mean the Dispute Resolution Center has reached out to you, has asked you to fill out the self-assessment, and you did not fill it out. Or the DRC reached out to you, asked you to fill out the self-assessment, you did fill it out, then they reach out to you again saying, here's the date available for mediation, and you don't respond, right? It is so important if you get a notice like this, you should be checking your email every day. You should be checking your phone. If your email or phone or contact information changes, you should be proactive and try to reach out to the Dispute Resolution Center and say, it's changed. Or reach out to your landlord and say, here is my new contact information, and put it in writing. So then that way, if landlord tries to tell everybody, oh yeah, tenant's phone number is, this number, you can be like, no, I told you that that's not my right phone number, that it's this one. Let's say you respond and an agreement is reached. So that would be through mediation. You respond, you have a mediation, you and your landlord come together, an agreement is reached, yay, you're good to go. Or you respond and agreement is not reached. So if you respond and an agreement is reached, yes, right? That's the best case scenario. What that means is you can breathe a sigh of relief. The eviction's not going to be moving forward because you and your landlord have come to an agreement. If you violate that agreement that was drafted by the mediators at the Dispute Resolution Center, landlord can request a certificate from them, and we'll talk about what they do with that certificate. So it is important to remember that these agreements are binding. Don't sign something unless you can stick to it. If you go to mediation and you and your landlord just cannot find common ground, it happens, unfortunately, and essentially what that means is now landlord can request a certificate from the Dispute Resolution Center. The reason why this certificate is so important is because the law says that the landlord has to get a certificate before they can move forward with an eviction. So they have to go through this process. They cannot just try to skip it. I've seen them try to skip it. It doesn't go over very well for them. And so that's why it's so important for you to keep, checking your email, checking your text messages. If you get a notice, just attend one of the Thursday clinics so you can see where you're at, because I don't want you to miss out on your opportunity to mediate because you didn't get an email or it went to your spam or what have you. Okay, next slide. Okay, and again, 14-day notice, we're on the final notice. This is more of the traditional notice. The recent, I guess it's been a few years now, did change it to be a longer notice. But what this is a 14-day notice to pay, rent, or vacate. What that means is you either pay the amount that's on it or you leave. Otherwise, the landlord's going to move forward with an eviction. Again, right now, a repayment plan is required. Like, landlord has to offer that payment plan. That requirement is from March 1st of 2020 until 6 months after the public health emergency is ended. That means 6 months after the month of October, because the public health emergency for COVID-19 ends this month. So look forward ahead 6 months. After that 6 months, landlord is not required to offer the payment plan anymore. But for rent during that period of time, and for the foreseeable future, for a few months anyways, landlords still have to give you that payment plan. So you get a 14-day notice. You have multiple options. Pay the amount due. Again, do your math first, though, right? That's like the very first step. Look at the amount that landlord says you owe. Look at your receipts. You know how much your monthly rent is. Do the math, and if it's not adding up, ask why, right? Get documentation of your ledger. Get something to show, okay, now I know. Or if it's not adding up and you dispute it, you are now in disputing land, and that's more like raising a defense. Like, no, I don't owe this at all. We'll talk about what to do when you get notices in general, but if you're in a situation where you're disputing amount owed, like let's say landlord for the month of October gives you a 14-day notice, and you're like, excuse me, I paid October rent. Here's the date I paid it. Here's how I paid it. Put that in writing and respond to the notice to your landlord. Assume positive intention, right? I wouldn't go in there like, what? Like, I can't believe you're doing this to me, because sometimes there really are just computer errors. And I know landlords oftentimes have these notices kind of set in their system to be printed out automatically if someone is behind on rent, and maybe they just didn't manually enter it in yet, right? So written notice letter back to landlord, hey, you gave me this 14-day notice. Here's proof that I paid my rent for the month. Please confirm that you are rescinding this notice, right? So then that way you can kind of breathe a sigh of relief. But if you do know you owe it, let's say October was just a tough month, you owed it. Now that we're in the second half of the month, second paycheck came in, you were able to pay the amount owed. If you pay the amount owed on the 14-day notice, you've done what the notice has told you to do, right? You paid or you left, so you paid it. Get a receipt, but that should give you the knowledge of, no, I'm good, I paid what the notice said to pay. Or we're gonna be looking at going into mediation. And I know with mediation, we talked a lot about the payment plan, but mediation is also a good place to go to if you're like, you know what, I just need to leave, right? I can't afford the payment plan, I can't afford this rent, I have alternative housing that's being set up, and I want to talk about a vacate date with my landlord so that I can move out without having to go through an eviction process, so that my landlord doesn't have to go through that process, and so that we all know what date I'm leaving. And you can also kind of argue different terms, right? Some mediations, a landlord might be willing to waive the back rent owed if you agree to leave. So those are things to kind of think of. But mediation isn't just for payment plan. It can also be just to negotiate a vacate date. You do not have to, though, okay? Landlord cannot evict you without going through this process and getting a court order. So if landlord tells you, you have to pay this or I'm gonna kick you out tomorrow, that's not how this works at all. But it is an option for you if it's something you want to pursue. Okay, so then we say, well, if you can't fix it right up front, then the next step would be going through King County Dispute Resolution Center and the mediation process that we just talked about. Next slide. Important note for subsidized tenancies. Honestly, if you are in a subsidized unit and you get an eviction notice, contact legal aid. That would be my biggest recommendation. So when we talk about subsidized units, what that means is your rent is based on your income and household composition. If you're unsure if you live in a subsidized unit, a good way to kind of know if you do is if every year they ask you to do an annual recertification, or if at some point in time when you initially signed up for the tenancy, you had to fill out all this information about your income and your household composition. These subsidies can range from housing choice vouchers where the tenant gets the voucher from the housing authority, and wherever the tenant goes, the voucher goes with the tenant, and they can use that voucher with each landlord, or it might be connected directly to the unit. Sometimes people don't know that they're living in what's called low income tax credit properties, oftentimes because their rent is still fairly high for a subsidized building when you're in an LHTC unit. If you are in a subsidized unit, your landlord has to follow certain federal rules and regulations, okay? And that's why I'm saying contact a legal aid organization, because there's other case law, there's other notice requirements, there's other issues that might be coming up that we would want to take a look at. But generally speaking, with the CARES Act, in response to COVID, landlords are required to give you a 30-day notice. Now, to be honest, this doesn't really do much because the process of getting the 14-day notice and the payment plan, going through mediation, all of that oftentimes takes 30 days anyways. So usually if you're in a subsidized unit, now you're getting 4 notices all at once. You're getting the 14-day, a 30-day, a payment plan, and an ERPP notice, and then your hair is gonna catch on fire and you're gonna say, what is happening? I know it's frustrating, but they can give it all at the same time. If you're in a Section 8 voucher, the landlord also has to give the Public Housing Authority a copy of the notice to let the housing authority know that they are pursuing this process. So really, again, if you're in subsidized housing or you have a voucher and you get an eviction notice, call an attorney because we want to make sure that your voucher or your subsidy stays protected as well as your tenancy. Okay, so we've gone through the whole process. Unfortunately, mediation failed, no agreement was reached. Maybe you didn't get the notices, so you didn't respond. Either way, we are now in a situation where landlord has given you the notices. They gave the notices to the DRC. The mediation process didn't work out for you. Landlord requested a certificate from the DRC. The DRC issued that certificate to landlord. Landlord still has more they have to do before they can evict you, okay? If landlord says, I got this certificate, you need to be out tomorrow, no. You do not have to be out tomorrow. The certificate is not the magic ticket that gets you out that very day. Instead, landlord has to serve you with what's called a summons and complaint. And what this is the real formal initiation of an unlawful detainer action in court. The summons and complaint does not have to be filed with the court in order for landlord to serve it to you. So it's going to look like an official court document. It's going to say case number. Sometimes there is a case number, and that means, okay, it's been filed. Other times the case number might be blank. If a case number is blank, don't think, oh, this isn't a legit, summons and complaint, I don't have to respond to it. You absolutely do still have to respond to it. The good news is this triggers your right to counsel. So Washington passed a new law that says that tenants have a right to an attorney to represent them through this eviction process. And so if you get a summons and complaint, even if it's not filed with the court, contact Housing Justice Project. They had the table right over there. Housing Justice Project, through the King County Bar Association, is the wonderful organization that houses the right to counsel attorneys. Right to counsel attorneys, their only job, their sole purpose is to represent you in these court proceedings. So if you're working with another agency, like let's say myself, I might be assisting you when you get those first few notices to try to prevent it from getting to this point. But if you do get a summons and complaint, I'm going to refer you to Housing Justice Project and the right to counsel folks, because they're the ones that appear in court and would help the tenants in this process. When I say respond to a summons and complaint, it is not like you have to write down, a magical court brief and kind of go through all of this. It's called a notice of appearance. It's a one-page document, sometimes two. And it's literally you saying, I am the tenant, here is my name, here's my contact information, I want to dispute this eviction. And then you say, and here's how I gave this notice to either my landlord and the court, or just the landlord if it hasn't been filed with the court. The way you give it back, the summons and complaint will tell you exactly who to send it to, but usually there's like a address, so you can snail mail it, hand deliver it, fax it, things like that. I recommend you do, if you're gonna mail it, I recommend you fax a copy too, so then that way you get that nice fax confirmation sheet as proof that you actually sent it to who you're supposed to send it to. Okay, next slide. Okay, so a quick note on late fees. Even though we know already that late fees are not considered rent, and a landlord cannot pursue a rent-based eviction for things that aren't rent, another thing that's important to know is that there was a prohibition against charging late fees at all. So between March 1st, 2020 and December 31st of 2021, cannot charge any late fees. There should be no late fees on your ledger. If you request a copy of your ledger and you're seeing late fees during this period of time, a dispute letter should go to your landlord where you say, you can't charge me these fees, here's why. Late fees are allowed if rent goes unpaid for more than 5 days after the due date. Late fees, though, have to be in your lease agreement, okay? A landlord can't tell you, hey, you know what? People are so behind on their rent recently that I'm gonna be charging late fees from here on out, and here's the amount I'm gonna charge you. No, it's in your lease. If a landlord wants to change the terms of a lease, they have to give you a proper notice before they do that. So it has to be in your lease. It cannot take effect until after 5 days, so it's like a 5-day grace period in the beginning of the month. Also, if you are on fixed income like Social Security, you can propose changing the due date of rent 5 days from the landlord's due date to give you more time. I know oftentimes Social Security checks come in the mail. The mail can be a mess at times. You don't want to get penalized, for your rent being late if you're relying on a check to come into the mail. So you do have the option to offer that to landlord. But really for late fees, it's the things for rent-based evictions. It's important to remember landlord can't evict you for rent. That includes late fees. Landlord cannot charge you late fees from March 1st, 2020 to December 31st of 2021. Landlord cannot charge you any late fees that aren't identified in your lease that you've already agreed to. And those late fees can't start until after 5 days from the day the rent is due. Before we jump into just cause evictions, I am going to make one quick note too. If you received eviction rental assistance through King County, EPRAP, it's another acronym that is escaping me right now, but it was open, it's now through United Way. That happened, like a year and a half ago now. If you received eviction or rental assistance from King County, it's important to look at a copy of the contract that your landlord signed. Because some of these contracts, this assistance usually goes like the back rent owed plus 3 months of future rent is usually what we're talking about. Some of these contracts have additional protections in them that you might not know of. And it's not all contracts, unfortunately, but it is some. have a 6-month prohibition against landlord from being able to evict you for failure to pay rent from the last payment they received. So let's say this rental assistance paid your back rent, your 3 months moving forward, that ended in June. If that restriction is in there, that means July, August, September, October, November, December, your landlord cannot evict you for failure to pay rent during that period of time. Another protection that are sometimes in these contracts is landlord cannot increase your rent during that period of time either. So if you did receive, if you're like, gosh, I know that I got rental assistance, and if it was within that 6-month period of time, I recommend reaching out to a legal aid organization, and also reaching out to United Way. They have a website where you can do an inquiry form and ask for a copy of the TRAP contract, or you can just say the contract my landlord signed when they accepted this rent, because that would be a defense to the eviction, right? If landlord said, yes, I will take the rental assistance, I pinky promise King County I won't evict tenant for failure to pay rent for a period of 6 months, and then they try to do it, they're violating that contract, they're putting themselves at liability, they actually have to pay everything back to King County, but mostly that's a defense to you, to the action, right? Hey, you can't do this because you already agreed you wouldn't. So just kind of remember that if you had received assistance, or you have friends who are going through this and you remember them talking about receiving assistance, be aware that that could give them an additional protection that they might not know of. Okay, so we're gonna go into just cause evictions. So like I said earlier, landlords are prohibited from evicting you without cause. What this meant is, in the past, when your lease was up, a landlord could give you a notice and say, I'm not gonna rent to you anymore. Now they have to have a reason. There are some exceptions. Most of the time you are protected where landlord has to give you a for-cause notice. If you get a no-cause notice, or a notice of non-renewal, and landlord is saying you need to leave, contact the legal aid organization. One of the things I'll be asking you is, what is your rental history with this landlord? Because generally speaking, if you ever entered into a month-to-month lease with them, you're protected. But one of the times you might not be protected is if you had a year-long lease and you've just been under that year-long lease, and now it's the first time that year-long lease is up. It really is just dependent on your circumstance and what we can prove, and there's still arguments we can make. I'm borrowing trouble, that's my job, right? Most of the people I see, I've only had this happen once where they got a no-cause notice and they contacted our office. Because it's rare, and with that situation we were able to dispute it and say, no, you don't actually have the right to use this notice. So if you get a no-cause notice, contact a legal aid organization, because generally speaking, landlords have to have a reason to evict you. The statute provides 17 examples of what is considered just cause, one of which is unpaid rent, which we already talked about. Don't worry, I'm not gonna go through all of the examples. We will talk about some of the notices, but we are going to talk about kind of the most prevalent that I see, and that's 10-day lease violation notices and 3-day nuisance notices. And then we'll kind of go over a few as well. Next slide. Okay, so 10-day lease violation notice. This is very, very common. It has to be a substantial breach of a material term of your lease in order for a landlord to be able to move forward with an eviction based on it, right? So we're not looking at oh, your lease says you can't plant certain types of flowers in front of your yard and you planted that flower. I feel like a judge would be like, what are you doing? Plus, it'd be a fairly easy thing to fix. Just remove the flower. But it has to be a substantial breach of material term. Usually what we're looking at, especially with subsidized housing, would be, let's say your lease requires you to do that annual certification where you say, here's my household composition and my income, and you don't do that. That would be a substantial term of your lease. Quiet hours, right? You're making it so that your neighbors can't enjoy the use and quiet enjoyment of their own building. That could be a substantial breach. I'm trying to think of some other examples. Honestly, usually when people come in with lease violation notices, they're so far-fetched. I'm struggling to find a good example of what would be a substantial, breach. This would be more like nuisance. Yeah, essentially it just has to be a material term of your lease and you break it, and you do not just a little, but a substantial breach. It also, this notice has to be specific and provide you the opportunity to fix it, okay? The specificity is really important, because oftentimes when I have people coming contacting me saying, hey, I got this 10-day notice, it's literally copy and paste of a section of your lease, and landlord's like, you violated this. And then that's it. And tenant's like, I have no idea what they're talking about. That's not a proper notice. The whole entire point of this notice is to give you, the tenant, a heads up of, hey, I think you broke this part of your lease, you get 10 days to fix it. If it's not specific enough to even let you know how you broke your lease or what part of the lease you broke, it's an invalid notice. And again, provide that opportunity to cure, so give you the ability to fix it. So with a 10-day notice, usually the defenses we're looking at would be maybe it's just an improper notice. Maybe what landlord is alleging never actually happened. Maybe it did happen, it was a substantial breach of a material term of your lease, and you fixed it in the 10 days. I would put that in writing, notify landlord that it's been fixed and how, so that way landlord knows you responded to the notice. If you get 4 or more lease violation notices in a 12-month period of time, your landlord can move forward with a 10-day notice that doesn't have to say you broke the lease at that point in time. It can just be, you've broke the lease 4 times in 12 months, I want you out. So if you do get a 10-day notice and you're like, well, my landlord, never followed through, or I got the 10-day notice and nothing happened, I'm in the clear. I recommend you respond to any 10-day notice you get saying, no, that didn't happen, or that's not a material breach of my lease. Raise whatever defense you have, because then that way you're setting yourself up. So if you're in a situation where your landlord's just trying to give you these notices to get you out, you've been disputing them, and you can show that you've been disputing them. Because if they get up to 4 and they give you that other 10-day notice, the argument of I haven't broke my lease doesn't apply, because the notice is just, we've given you these enough, we've given you 4 different notices in a 12-month period of time, we want you out. So just remember that, because I have had tenants where they say like, yeah, but my landlord never did anything after I got the 10-day notice, so we're good. I'm like, you very well could be good, right? Assume positive intention. But my job is to look forward ahead and think what problems might come from this, and one of them would be landlord's gonna give you 3 others and then give you this other notice. Another common notice that we see is the 3-day nuisance notice is usually what it's called, but it's also for crime and waste. Crimes on property, repeatedly causing issues for neighbors, like significant issues, safety issues, damaging the property. That's all something that your landlord could give you a 3-day notice on. Again, the notice has to be specific and identify all facts and circumstances that were known to landlord at the time they gave you this notice. The big difference between a 10-day and a 3-day is you do not have the opportunity to cure a 3-day. What I would say is at times landlords might look at the notices and the options for how they can move forward with an eviction. They see a 3-day, they think, that's the shortest notice, I'm gonna give it a shot. So it still has to be for crime, nuisance, or waste. It can't just be 3 days because you're annoying me, or 3 days because I don't want you to live here anymore. Or I've heard a lot like, oh, you disrespected me. Okay, well, is that a crime, nuisance, or waste? But one of your defenses can't be, oh, I fixed it, okay? Really for this, the defenses are, that didn't happen, or what you're saying happened did, but it does not rise to what is defined as crime, nuisance, or waste. Or your notice is incredibly vague, you just gave me a 3-day notice saying I committed one of these things, but you didn't tell me. When we talk about vague, what we're looking at is like a lack of dates, right? Like, I got a complaint from a neighbor that you bothered them, and so here's a nuisance notice. Like, no, we should be looking, a specific date, what actually happened on that date that is the nuisance, waste, or lease violation. It really should be enough for you to be like, oh, I know what landlord's talking about, and here's my defense to it. If you have no idea what they're talking about, really that's an indication that you have an argument that this notice to begin with is improper. Next slide. Okay, so then here's some other examples. We'll kind of go through these quickly and then we'll open up to questions. These are not like all encompassing examples, but just like to be aware of. A 20-day notice if you share the unit or access to common kitchen or bathroom with your landlord. They can give you this notice. So like if you're in a situation where you're like renting a room, right, but you guys share the kitchen together, the law's given landlord an ability to say like, okay, well, you can pick and choose who you share your kitchen with, right? Sexual harassment, this would be tenant towards someone else. So if you sexually harassed another tenant or the landlord, then they'd be this notice. Sexual offender, if you were a sexual offender and you did not disclose that when you applied for the unit and you were required to, and landlord becomes aware of that, they can give you a 60-day notice. Next slide. If the unit's been condemned, right, you can't live there, here's a 30-day notice. If this happens, also contact legal aid, because we would be interested in looking at if there was a breach of the implied warranty of habitability, which is a fancy way of saying landlords have a duty to provide you with a space that is habitable and safe for you to live in. And if they breach that duty, there could be issues and there could be remedies available to you. Transitional housing, so if you are in a transitional housing unit, 30 days or as much as possible. So really like the main example we're looking at for here is you no longer qualify to be in that transitional housing. Lease overstay, this is interesting. It does not, when we say does not apply to periodic tenancies, we're looking at like month to month. Let's say you were in a year-long lease, right? Everything was good. Your landlord says, hey, I want to renew your lease. Because your previous lease says no month to month, you have to be in a year-long. Here's your new year-long lease, and you don't sign that new lease. Your landlord could move forward with a 30-day notice saying like, hey, they've overstayed, right? They're not on a lease. I don't want them to be a month-to-month tenant. They didn't sign the new lease I gave them, so I want them out. It does have to be a reasonable lease. It can include higher rent. They have to give you proper rent increase notice. But if like the lease is way different, right, or incredibly unreasonable or includes like just way different terms, contact an attorney, because there could be an argument we could make that like, hey, this isn't actually a similar lease and so this section of the law doesn't apply. But usually this is just like landlord wants to keep you on a year-long lease, you didn't sign a new one that was the same. You can't force a landlord to agree to have you be a month-to-month tenant. If you're not on the lease, if you're living there and landlord's like, wait a second, you're not on a lease with me, they can give you a 30-day notice. Oh, real quick with that 30-day notice, it should be to join or leave, right? Like you have 30 days to apply and get on the lease and the end or leave. So you can cure that one. Okay. False application, very similar. We've already talked about if you made a false application, it was intentional, and it was also a material part of the application when you applied to be a tenant there and landlord finds out, they can give you a 30-day notice. If landlord's no longer renting the unit for business or economic reasons, they're like, you know what, it's usually we're looking at like a house, right? Like I'm done, right? I'm done renting this house out I no longer want to be a landlord anymore. They can give you a 60-day notice. If landlord moves in, again, we're looking at houses, right? Landlord moves in, either the owner or their immediate family is gonna move into that house, they have to give you a 90-day notice. Now, if this happens, this would also be a good situation to contact an attorney, because obviously if your landlord has like 5 homes and they're all of a sudden saying they're moving into yours, it might be a red flag and maybe there's some defenses there. Or a landlord elects to sell, another 90-day notice. Again, this is for a house and landlord's like, I'm done, I'm gonna sell it. Unfortunately with the electing to sell, I have had tenants that they're like, but I know that they're not gonna sell it. I think they just want me out. The statute says if landlord doesn't put it on the market or list it with a real estate agent within 30 days from the date you leave, then you can challenge it. Of course, this is a situation where I say the law has teeth but no bite, because you as the tenant, right, that's not gonna help you. You've already had to move out of the unit. But just be aware that your landlord does actually have to list it within 30 days from the date that you left. So if you drive by and you're like, it's never been listed for sale, and I heard that they moved another tenant in there, talk to a legal aid organization, because then there'd be a defense that that eviction was actually unlawful because they used this notice improperly and they lied. It's not up here, but another example that I just came across is a 120-day notice, and that's because they're gonna demo the building. So be aware of those. Okay, next. Okay, so I've mentioned unlawful evictions. Self-help is what we call it. Evictions are illegal in the state of Washington. What that means is your landlord cannot evict you by themselves, right? They don't have the power to be like, I need you out, you're gone, I'm forcing you out, you're gone right now. They have to go through the process. They have to give you these notices. We're looking at at the very least, a 2-step process where they give you the first notice and then they give you the summons and complaint, and it plays out in court. With 14-day notices, we've already talked about how there's oftentimes multiple other notices. With subsidized housing, there are oftentimes additional procedures that they have to go through because now they're terminating both your subsidy and your tenancy, but they cannot just say, I want you out. And so some of the classic examples of this would be like you go home and your locks have been changed, right? That is an illegal lockout. The sheriff is the one that executes the court order. Landlord cannot do that. You should not be in a situation where you come home and your locks are changed. If you are in that situation, contact legal aid right away. Or they turn off your utilities. Okay, well, I'm not gonna lock you out, but guess what? No electricity, no water for you, because I'm now trying to, it's called constructively evict you, right? I'm not actually locking you out, tenant, but I'm gonna make it so that you can't live there. That's still an unlawful eviction. Threatening law enforcement involvement, if they're like, I'm gonna call the cops and kick you out right away, that could be considered an attempted unlawful eviction, obviously. Let's say you go home and the door is unlocked, or your key works, your water is running, your electricity is good, but all your stuff is gone. Again, another form of constructive eviction. They can't remove you after you assert your rights. Now this is more like a defense to an eviction, but if you, let's say, got a 14-day notice and you're like, hey, that doesn't apply to me, I paid my rent, here's my proof. Obviously, if you win on that, let's say then the very next day, they give you a 3-day notice and they're like, you're being a nuisance, I want you out. Now you have two arguments, right? First of all, that wasn't being a nuisance. But second of all, this is clear retaliation. Another example we see this more often is for habitability or repair requests. Like you put in a repair request to your landlord, like, hey, X, Y, and Z isn't working. And then the next day, landlord gives you an eviction notice or says, hey, you have to get out of here. I'm not gonna fix it, you just need to leave. Again, a sign of retaliation. There is a rebuttable presumption that it is retaliatory if that happens within 30 days from the date that you do it. What that means is landlord can counter and say, no, here's the other reason why. So for example, I put in a repair request at the end of September, middle of October, I get a 14-day notice. I'm like, I think he's just retaliating against me because I made that repair request. But if I'm actually also behind on rent, landlord's gonna have a pretty good argument that no, I gave the 14-day notice because you're actually behind on rent and that's what I need to do. Or an improperly filed unlawful detainer. So an example for this would be that situation that we just talked about where, let's say, landlord gives you a notice like, oh, I'm gonna be selling the unit or I'm gonna tear it down. You stay in the unit, they evict you, and then landlord never does the thing. Instead they re-rent it. Okay, well, even though you've already been evicted, you could argue that that was an unlawful eviction, and that would open up landlord to liability. Northwest Justice Project is a great resource if you feel like you've been unlawfully evicted. They are the ones that can kind of handle that proactive litigation. Next slide. Okay, so you got an eviction notice. Now what do? Take a deep breath, okay? I know that coming home and seeing these on your door, or if you were personally served and you get a knock and you open it and they say, are you Jane Doe? Yes, I am. Here you go. That is so stressful, right? And it makes total sense that you or your friends or family who are going through this are going to be in a moment of crisis. Take a deep breath. Do not ignore it, okay? I have had people where they come to me for help way down the line and I say, but you should have gotten these notices. Yeah, I came home and I saw stuff on the door and I was just, so overwhelmed and stressed with everything. I took it off the door, I put it on my kitchen table and I figured I'd deal with it later. You have to deal with it now. Take a deep breath and then make a copy of them, okay? Right? You wanna save them. Save them because I guarantee you the first thing any legal aid attorney or other attorney is gonna ask you is, do you have a copy of the notices that you got? Because we need to see what landlord gave to you. Note how you received the notice, because landlord has to follow certain procedures. Usually we see it being posted, so a copy of the notice is posted on your door and a copy is mailed to you. But if you only got it on your door and you never got it in the mail, make a note of that, because that is technically a defense to an eviction. If that's the only defense, would it be enough for a judge to throw out the whole thing? Depends on the judge, right? I would say I've had situations where judges have been like, yeah, I'm gonna, really keep it firm and be like, absolutely not. You didn't serve it the right way. And I've also had a judge where they're like, yes, the landlord didn't give a copy in the door or in the mail, but tenant still did get notice and acted on the notice. And so no harm was done to the tenant. But still make a note of it because that is a potential defense and it's an issue that you'd want to bring up. Okay, and then contact legal aid provider to go over options. Usually with evictions, we're looking at cure, dispute, or vacate. There can be other options, but generally speaking, they're gonna fall into one of those categories. Curing it is, or a mix, right? Or it could be a mix of categories. Curing it is exactly what it sounds like. This is like usually a lease violation or 14-day notice, right? Whoops, landlord, you're right, you did everything right, I'm in the wrong, I'm gonna fix it. I fixed it within the time period. Dispute it. No, landlord, you're wrong, I didn't do what you're saying I did, or if I did, it didn't rise to the, to the definition of nuisance, or it's not a substantial breach of my lease agreement. Or vacate, like, yep, landlord did everything right, I don't have a defense to this, I can't cure it, it's not something I can fix, I'm gonna want to leave. There are other strategies and things that you can do, but like I said, it usually falls into one of those three categories. But truly, truly, truly remember, your landlord cannot lock you out without a court order, okay? They cannot do it. And they say they can do it, and they will tell you, I can call the sheriffs and get them over here to lock you out right away and do it. They will tell you, I got a certificate from the DRC, I can get you out tomorrow. No, no, no. They have to give you the right notice. They have to give you a summons and complaint. You have the ability to respond to that. If you do, which you should if you want to fight it, you have a hearing. Then the judge has to issue an order. Then the sheriff has to execute that order. At no point in time in this eviction process you should be in a situation where a landlord is the one who is forcibly removing you from your unit. If they do that, you should call the cops on your landlord and say, my landlord is forcibly removing me from my unit without a court order. And you should also contact legal aid, because that's an absolute no-go. Next slide. So you heard me say a lot of times, contact legal aid, contact legal aid. Here are some options from resources for you. So obviously there's Eastside Legal Assistance Program. That's where I work. We do what we call pre-eviction work. That's pre-summons and complaint, right? If you got a notice from your landlord, we can help you out. We also work very closely with Tenant Law Center, Northwest Justice Project, and the KCDRC to provide weekly clinics. So we have the Thursday clinic with the Dispute Resolution Center. If you've received a 14-day notice, that's on Zoom. It's from 10 a.m. to 12 p.m. We have a Tuesday clinic with Northwest Justice Project and Tenant Law Center. That is for overflow cases from the Thursday clinic and also habitability issues. So we'll do a whole presentation on repair requests, what your rights are there, what landlord's duties are, debt disputes with your landlord if your landlord or previous landlord says you owe money, stuff like that. If you contact one of us, either Tenant Law Center, NJP, or myself, we would be able to refer you to that Tuesday clinic. Also a note, ELAP does more than just housing. I'm just the Housing Stability Program attorney, but we have other programs, and we have a very robust clinic program. I know we have like a wills clinic and immigration clinic and family law clinics, and we have volunteer attorneys who agree to take our cases. So if you're experiencing another legal issue outside of landlord-tenant problems, feel free to contact ELAP, because we'll see if we can put you in one of our clinics. Tenant Law Center also does pre-eviction work. If you are a Seattle resident, they're a great person to call, because they know there's different rules that Seattle landlords have to follow. But they can also take cases throughout the county. Again, pre-eviction work, so very similar to me. If you get a summons and complaint, they're not the ones to call. Any notice before that, you can reach out to them. Housing Justice Project. That's who you contact if you get a summons and complaint. If you Google them, they have an online intake form, a phone number, and an email. If you get a summons and complaint, I recommend you make a note of when your deadline to reply is with that notice of appearance, right? You can find notices of appearance on Washington Law Help. If you Google that and notice of appearance, they have an option for you. Also reach out to Housing Justice Project. I like to do it in two different ways. I'd say online intake form, at least in my experience, is really easy because they can track it. If you call and leave a voicemail, I highly recommend you send a follow-up email saying I called and left you a voicemail. When you contact them, they're gonna wanna know, did you get a summons and complaint? If so, what day? When is your deadline for a notice of appearance? And have you filed a notice of appearance? If you haven't heard from them, don't wait to respond with your notice of appearance. You should still respond, right? As if, you reach out to them, but you don't want to miss a deadline, because they might be backed up and they might reach back out to you the day before your deadline, and now you're in a stressful situation. file your notice of appearance. They will do their own thing they need to do to connect themselves to your case. If you're in a situation where, for whatever reason, everything has fallen through the cracks, or you forgot to contact Housing Justice Project and you're in a hearing in front of a judge for an eviction, tell the judge, I know I have a right to an attorney and I want an attorney to help me with this, right? Or I contacted HJP and I haven't heard back, or whatever. Don't be silent, speak up, let them know that you want to trigger your right to counsel. Solid Ground and Tenants Union are also both great organizations that provide educational presentations. They work on tenant advocacy and education. They oftentimes don't have attorneys present, but they know all of us, and I get referrals from Solid Ground often. So if they think like, yeah, this person's in a situation that needs kind of more help or more assistance, they can help you with referring you out to a different organization. Then WashingtonLawHelp.org, you already heard me mention it. This is a wonderful website. I highly recommend you look at this website before you are in a moment of crisis and read up on your rights as a tenant. They have a whole section where they go about like what can be included in your lease, what can't be, the process of raising rent, what landlord has to do. What if you're in a situation where you need a repair being done? And not only do they go through those rules and what landlord has to do and what you have to do, they also have sample letters that you can either download and fill in or print out and fill in, handwrite in and give to your landlord. So it's a great resource. It's a good resource to review, like I said, before you're in a situation where you're like, I really need it, so that you know if that happens, you already know kind of where you're supposed to go and what your rights are. But any questions for me?